Hello. I'd like to call to order the Planning Commission meeting this Thursday, October 17th at 6:30 here in Council Chambers. Our first order of is Pledge of Allegiance, and I was hoping Mr. Jeff Seymour, would you mind leading us with the pledge?
This is not going to call up my time or anything when I get up. No. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Jeff. Roll call, David?
Good evening. Commissioner Jones.
Here.
Commissioner Hoopengarner.
Present.
Commissioner Erickson.
Present.
Commissioner Buckner.
Present.
Commissioner Elchel.
Here.
Vice Chair Bass.
Here.
Chair Carvalero.
Here. Thank you, David.
And we have a quorum.
Do we have any changes to the agenda? Do I have a motion to approve the agenda then?
Motion by Commissioner Erickson, seconded by Commissioner Hoopengarner.
Got it. I just want to make a quick note. I need to abstain from the, or I guess we're not going to consent yet. Never mind. Just kidding.
And the agenda is approved as presented.
Thank you, David. So we have 3 sets of meeting minutes. I'm going to do them each individually because different commissioners were absent at different meetings. So I'd like to have a motion for the approval of the meeting minutes from September 5th.
Motion by Commissioner Hoopengarner, seconded by Commissioner Erickson. And minutes for September 5th, 2019 are approved as presented.
Great, thank you, David. Now I need an approval for the meeting minutes from September 19th.
Motion by Commissioner Buckner, seconded by Vice Chair Bass. And the minutes are approved for September 19, 2019, noting Chair Carvalero absent and Commissioner Jones abstaining.
Wait, you were, Commissioner
Actually,
Cavalier?
I did that wrong. I meant to abstain from October 3rd, not September 19th.
Okay, we'll make that correction. So your
Great,
vote
thank
would be reflected as a yes.
So now I need a motion to approve the minutes for October 3rd.
Mr. Chair, I just have one correction. In the meeting minutes from October 3rd, when we were discussing the draft EIR, I said the word malfeasant. I meant deficient. So if that could just be corrected for the record.
Great.
Thanks.
Thank you.
I also have one change, and that is on page 73 of 89. It says, currently it says Commissioner also. It should say Commissioner Altschul.
Noted for both.
I accept those corrections.
I have some corrections as well.
Should I pull my motion?
On page, sorry, David, I didn't get you these in advance, but on page 22, in row 19, the word about needs to be inserted between speak and CC2. So speak about, CC2. On page 25, oh, sorry, wrong page. On page 60, row 21, we need to insert the word not. The sentences, they vary anywhere from 3,000 to 9,000 square feet in terms of how many square feet of housing and parking and all that adding up. It does not in any way, in any circumstances, add up to the stated square footage. On the bottom of page 61, row 24, El Lavato should be Elevado, the street. Elevado. And that's it.
Thank you, Commissioner Hoopengartner.
I accept those corrections and continue my motion to approve the minutes.
And the minutes for October 3rd have been approved with the noted corrections, noting Chair Carvalero abstaining from that vote.
Thank you, David. Do we have any public comments at this time?
We have one, Mark Horn.
Great. If you can come to the podium, state your name and your city of residence.
I'm Mark Horn. I've been a resident of West Hollywood for 15 years, and I'd like to acknowledge that the analysis and recommendations contained within item 9B that I agree with. I do not dispute any of the facts. I wasn't sure that I could prove a material violation of the Brown Act, but I knew that something odd had happened. And given the use of the word avoided in the response and recommendation, I will take on faith that the city will try to come up with modifications as appropriate that would allow an applicant to respond to a design review memo, yet also provide an opportunity for the city to see that, the neighbors or the public to see that before the meeting. And I understand time constraints and all of that. That's maybe a tough thing to achieve. But I would also suggest that no city resources be used sending me a letter, that just note that I've acknowledged and don't dispute that. And thanks for your time.
Thank you.
That was our last public speaker.
Great. Thank you, David. John Kehoe, would you like to give us a director's report?
Thank you, Chair and members of the Commission. John Kehoe, Director of Planning and Development Services. I have several items tonight. First is just talking about items on the City Council agenda for Monday. There are 2 zone text amendments on the agenda for the council to look at. They had previously looked at them and then had continued the 2. So as scheduled as part of a public hearing is a zone text amendment on the definition of dwelling units. So that's come before the Planning Commission in the past. And also is a zone text amendment regarding projects that span commercial and residential zones. So those 2 items are both back on the City Council agenda. Also of interest to the Planning Commission is a new business item that's a council item. Would possibly result in a zone text amendment if it's approved, and that would be a discussion of the maximum average unit size in commercial zones. You know that we have a maximum average unit size in our residential zones, so there's an item to talk about possibly adding that to our commercial zones as well. And then 2 other items I would like to mention. Excuse me. First has to do with our efforts on bringing Metro to West Hollywood. So Metro will be hosting community meetings to gather feedback about future rail service to West Hollywood, including one in West Hollywood and one really close to West Hollywood. The one in West Hollywood will be on Tuesday, October 22nd, so that's next week, from 6 to 8 p.m. at Plummer Park Fiesta Hall. And then on Tuesday, October 29th, from 6 to 8 p.m., there'll be another meeting at Rosewood Avenue Elementary. And I'm also told that the West Hollywood Advocates for Metro Rail, WHAM, will be providing free pizza, drink, and giveaways while supplies last if you arrive at these meetings at 5:45. And again, this is about trying to bring rail into West Hollywood. And then finally, I want to note that the City of West Hollywood earned a status as a 3-star certified community. The City of West Hollywood has been recognized as a 3-star certified community by the Star Communities rating system. STAR is the nation's leading framework and certification program for evaluating sustainability at the local level. This independent third-party verification program has recognized the city's commitment to providing a sustainable, resilient, and livable community. Certification places West Hollywood among the first ranks of sustainable communities nationwide, and only 3 other communities in California have earned this STAR status. And you can learn more about our efforts by going to sustainable living by visiting www.weho.org/gogreen. And then also kind of on the sustainability issue, you may notice that on your Twitter feed, we're now doing Sustainable Sundays. And so we're giving out little announcements on how everyone can be more sustainable. So that's all I have to say tonight.
Thank you, Mr. Kehoe.
I have a quick question, if
Go
I
ahead.
may. Chair, thank you. John, I'm sorry, what did you say the other ZTA was? It was project spanning commercial and residential zones at council on Monday. And what was the other one?
It was the average unit size, no, sorry, that was the city council. So it's the definition of residential dwelling unit.
Got it,
The
thank
long-term
you.
definition. Right.
That's
Chair.
all, thanks.
Okay.
Any other questions from commissioners?
How was the planning open house?
Oh, the planning open house was really good. I think we were in competition with the Democrats' debate, so we didn't have quite as many people as we were hoping for. But we still did get quite a few residents showing up to the meeting and going around to the different tables. So it was still pretty successful, and we'll continue to do it next year and hopefully get the word out for more folks, because I think it is important. It's a great way for our staff to interact with members of the community on a much more informal basis when it's not in this type of a setting, and so it's a much easier way to communicate back and forth.
Is there an update to the Edible Parkway Greens green project that was done a few years back since you're doing Sustainable Sundays?
I don't have anything I don't remember anything about that right at this moment, so we can find that out for
Yeah,
you.
just wondering. Thanks.
Right, then we'll move on to, thank you, Mr. Kehoe. We'll move on to items from the commissioners. Do we have any comments? Commissioner Hoopengartner.
We have a number of projects coming up before us in the next number of months that are quite large and involve an EIR. And I'd like to make a suggestion, recommendation to staff and my fellow commissioners, and like your input on this idea, that we separate the certification of the EIR as a separate process, that is what we pursue first, we vote, and then from there review the related plans, et cetera, proposed by the applicant, so that we aren't conflating those two separate decisions. And I think that might make our process flow more smoothly. And it's just a thought and a suggestion, and I don't know if anyone has any ideas about that.
I'm sorry, can you repeat that? I'm having a hard time hearing tonight, apparently.
It's the dead corner. I've been there for 2 years. Sorry about that. It's very hard in that corner to hear. Yeah. Yes. So when we have large projects, we have a big EIR to review, and our obligation is to certify or not certify that EIR. Then we also have the actual plans that have been submitted related to that EIR for the project that we are then asked to review and vote on. And my recommendation is that we actually deal with the items in the EIR as a separate item, that we take that on first, because without that certification, obviously, we can't do the project, right? So that we review the EIR. It can all be in the same meeting, just as a separation of process, that the EIR is reviewed and certified, and then we take up the actual project proposal. And that way, we're not trying to conflate questions about the EIR with the actual project. So
I defer to the chair on this, but I'd like to hear staff weigh in on this at the appropriate time.
Right, so staff will note this and we'll discuss this in the future.
Yeah, we can look into how that might work and whether it's advisable or not, and bring that back.
Thank you. Any other comments from commissioners? Nope. Approval of the consent calendar. We have 3 items, 9A, 9B, 9C before us. And if there are no objections, we can adopt them collectively.
I made a motion to approve the consent calendar.
Do we have,
But
Well, my only note is that I cannot actually, I don't know how this works, but I can't actually act on consent calendar item 9A because I was not at that meeting.
I'm also abstaining from item 9A.
so should we do them individually the way we did the meeting minutes? And,
I don't think we can just notate it for the minutes, right?
okay.
As long as, I'm abstaining from 9A as well. So as long as the minutes reflect.
So the record will show Commissioner Jones, Commissioner Erickson, and Vice Chair Bass abstaining from 9A when the consent calendar is approved.
Great. We have a motion on the floor, second by Vice Chair Bass.
May I clarify one item on 9B? Do you still want me to send a letter, even though Mr. Horn requested that no city resources be spent on writing a letter to him? It's part of the recommendation for 9B.
As the person who made the motion, I always feel like you should send an official letter. I understand the request. Thank you very much for saving city resources, but I think it's always good to have a letter signed, sealed, and delivered.
Okay.
In agreement.
We'll do that.
Commission. And the consent calendar is approved as presented, noting Commissioner Jones, Commissioner Erickson, and Vice Chair Bass abstaining on item 9A.
Great, thank you, David. So now we'll move on to our first public hearing, item 10A, 917-927 Hilldale Avenue. We're considering a request to demolish 6 existing dwelling units and construct 9 two-story townhouses. Mr. Doug Vu will present the staff report.
Good evening, Chair Carvalero, members of the Commission, Doug Vu, Department staff. The proposal before you is a request to demolish 6 existing detached dwelling units located on 3 parcels and construct a new 2-story townhouse development consisting of 9 dwelling units totaling 17,317 square feet on newly subdivided lots. The proposal also requests a variance to reduce the front setback, a modification to reduce the rear setback, and a reduction of off-street parking requirements for guest parking. The approximately 0.43 acre project site is located on the east side of the 900 block of Hilldale Avenue, which runs from Cynthia Street on the south and terminates at the south perimeter of West Hollywood Elementary School. The combined parcels have 135 feet of street frontage and 140 feet of depth, and slope downward approximately 6% from north to south and from west to east. The project site is currently improved with a total of 6 dwelling units and several accessory structures that were constructed between 1922 and 1939, including a 2-family dwelling at 917 Hilldale, 3 detached dwelling units at 921 and 923 Hilldale, and a single-family dwelling at 927 Hilldale Avenue. The project site and all the properties on the subject block that front Hilldale Avenue are within the R2 low-density residential zoning district, while the properties that front Hammond and San Vicente Streets are within the R4B multifamily high-density zoning district. Therefore, the project is surrounded primarily by residential uses, with most of the development along Hilldale consisting of 2-story multifamily homes in a range of architectural styles and periods of construction. The Montrose Hotel is directly behind the project site to the west, and as I mentioned earlier, the West Hollywood Elementary School is located at the end of the block to the north. On July 25th, 2019, the Design Review Subcommittee reviewed the project and commended its thoughtful design and expressed support for its compatibility with the neighborhood. Also at this meeting, a representative for the adjacent neighbor at 931 Hilldale Avenue expressed concern that the project would cast shadows onto their property and impact its solar energy system. Staff has been in communication with representatives for this adjacent neighbor since the application was submitted, which I will discuss further later on. Otherwise, no other public correspondence or comments have been received regarding the project. The 9 proposed 2-story townhomes are configured in 2 rows that are separated by a shared driveway. The north row contains 5 units that each range in area from 1,821 to 2,412 square feet. And the south row contains 4 units that each range in area from 1,783 to 1,790 square feet. The front entrance to the easternmost unit in each row will be directly off Hilldale Avenue, while the entrances to the remaining 7 units are through walkways that extend the north and south perimeter of the development. Each dwelling unit contains 2 or 3 bedrooms, flex space, and a private roof deck. 5 units have private gardens, and 2 contain basement spaces. Using the shared driveway for access, each townhouse will have 2 parking spaces in individual garages that are arranged side by side for the 5 units in the north row, or stacked using mechanical lifts for the 4 units in the south row. As proposed, the project requires a variance to reduce the front yard setback from 30 feet to 12 feet, a modification to reduce the rear yard from 15 feet to 13 feet 6 inches, and a reduction of off-street parking requirements to not provide the 2 guest parking spaces. Overall, the proposed townhomes are well-designed with a significant sensitivity to scale, accessibility, and sustainability. The massing, which is configured into 2 rows of units separated by the shared driveway, eliminates the need for multiple curb cuts to provide a more efficient use of the site, and the arrangement of the structures integrate thermal mass, natural daylighting, and cross-ventilation. The development also takes advantage of the site's sloping topography to nestle the buildings into the terrain so that the bottommost garage level in the north row of the units is subterranean. The architecture is modern, and the exterior materials are fairly simple, consisting primarily of cast-in-place concrete, stone tile, wood, cement plaster, and steel canopy frames in muted tones. The development is softened with a significant amount of landscaping that surround the buildings on all sides, with a diverse palette of grasses, shrubs, ornamental, and shade trees. The city's urban designer, Gwen Pugh, who isn't here this evening, stated that the proposed development is a carefully considered environment that will be enjoyable to inhabit, and that it will be an asset to the neighborhood and the city as a whole with its well-crafted design. So the project requires a 30-foot front setback based upon the average setbacks of the adjacent properties. The department finds that this requirement is an exceptional circumstance applicable to this property because it is located adjacent to the one property on the block with the deepest setback of 62 feet. This site condition was not created by the owner, and it presents an unnecessary hardship because of the strict application of the zoning ordinance would prevent the project site from being developed with a front setback that is similar to the other properties on the block, and generally throughout other R2 zoned lots in the city. This hardship would also deny the property owner the ability to construct dwellings on the front portion of the project site that other parcels have been able to construct on their respective properties, which is a substantial property right. So if granted by the commission, the variance would reduce the front setback to a depth of 12 feet, which is consistent with the setback pattern on this block, and therefore will not be materially detrimental to the public welfare, nor be considered a special privilege. The granting of this variance will also allow the property to be developed at the permitted density that will maintain an urban form and land use pattern that enhances the quality of life and meets the community's vision for the future. The Planning Commission approved a similar setback variance for the townhouse project directly across the street at 926 Hilldale Avenue just last year on September 6, 2018. If the variance is not granted, the department believes that the strict application of this provision would reduce the project site's buildable area by a depth of 18 feet and potentially eliminate 2 dwelling units, which would represent a significant loss of property rights. The department also finds that granting a 10% modification to reduce the rear setback from 15 feet to 13 feet 6 inches will not have a significant impact on the adjacent properties, primarily because the project's residential land use is compatible with the adjacent uses, which include a single-family dwelling to the north that is built to the rear property line, a 3-unit dwelling to the south that is under construction and will have a 23-foot rear setback, and the 4-story hotel to the west, which has an approximately 10-foot setback. The project includes side setbacks that are greater than the required width and would offset this modification and prevent any significant privacy and noise impacts to these adjacent properties. The proposed townhomes include a uniquely efficient approach to residential site planning in the city by providing 9 single-family townhome units, 7 of which will contain at-grade private garden or courtyard spaces that are designed as extensions of the adjoining indoor living spaces. So the nominally reduced rear setback will allow these interior courtyards for the 3 units in the north row to be more balanced in size with the larger courtyards for the exterior units. So under the zoning ordinance, the commission can approve a parking reduction if it finds that the intent of the parking regulations are met and that sufficient parking would be provided to serve the proposed use and potential future uses of the subject parcels. The proposed project does not provide the 2 required guest parking spaces, and the applicant is requesting a parking reduction. So the intent of the department finds that the proposed project meets the intent of these regulations as stated in the zoning ordinance because sufficient parking for all 9 townhomes have been integrated into the design of the building so that they are accessible, compatible, attractive, and well-maintained. Each unit will contain 2 parking spaces in a privately accessed garage with direct interior connection to the unit's habitable area that will be accessed by a shared driveway located between the buildings. This layout will reduce congestion and pedestrian conflicts in order to increase public safety and will comply with the access and maneuverability requirements for emergency vehicles. The site design will also eliminate 2 existing driveways and provide 3 new curbside parking spaces that will add convenience for the people of the city. So the adjacent property to the north of the project at 931 Hilldale Avenue contains a solar energy system that was installed in 2016. The city's solar access ordinance, stipulates that a residential structure cannot be built that would obstruct a solar energy system on a neighboring parcel to the extent that that system cannot function as intended in contributing to the energy needs of the property. However, the ordinance also states that the commission may modify this requirement if it finds that strict compliance would unduly limit property development or interfere with the development potential as envisioned for the area in the general plan or the zoning ordinance. The ordinance also states that if the owner of the affected property is willing to relocate the solar energy system, the city has the discretion to require the owner of the proposed building to pay reasonable relocation or retrofit costs to offset the impact caused by the new building. Because the property owner of 931 Hilldale Avenue contacted staff shortly after the project's application was submitted to express their concern regarding the proposed development's impact on their property, the applicant prepared and submitted a shade study that assessed the proposed townhome's impact on the neighboring property's solar energy system throughout the year, which was determined to be as much as 18% on the winter solstice and none at all during the summer solstice. To offset this impact and ensure that the affected solar energy system may continue to operate as intended once the proposed townhomes are constructed, the applicant has agreed to pay for the relocation and or retrofit of the panels that would be affected. The applicant also recently retained a solar engineer who has developed a remediation plan that would replace a number of the existing panels with newer, higher power panels. This plan was submitted to the department on Friday and immediately forwarded to the commission in a memorandum as a supplement to Exhibit D. Condition of approval 2.6 in the draft resolution will ensure compliance with this provision. So in the event the affected property owner is unwilling to allow the relocation or retrofit of the solar energy system, the strict adherence of the solar access provision would require a significant alteration to the project's design that may include eliminating the top floor of the townhomes in the north row or reducing the number of dwelling units. The department believes that this alternative would unduly limit property development and conflict with the general development potential envisioned for the area in the general plan and the zoning ordinance. So, in summation, the proposed project will develop 3 underutilized parcels with a new townhouse development that has been designed with high architectural quality, incorporates sustainable design principles, is complementary to the context of the neighborhood and meets the intent and provisions of the zoning ordinance. The requested front setback variance, rear yard modification, and parking reduction will allow a more integrated and desirable use of land and will not be detrimental to the public welfare. On balance, the project complies with the goals and provisions of the general plan, and the required findings for the demolition, development, variance, and modification permits can be made. Therefore, staff recommends that the commission approve the project subject to the findings and conditions of approval set forth in the draft resolutions. This concludes my presentation, and I am available for questions.
Thank you, Mr. Vu. Do we have any questions for staff at this time from commissioners? I'd like to have the applicant come to the podium and make their presentation.
Good evening, Mr. Chairman, members of the commission. My name is Jeff Seymour. I'm representing AEI A&R Hilldale. I reside in Westlake Village. First, I want to thank Mr. Vu for all his work with us. I also want to congratulate Ms. Alkire on her promotion as planning manager. I'm going to speak specifically regarding the concerns expressed by our neighbor, Ms. Osserhofer, at 931 Hilldale. Through her counsel, she has expressed her concerns relative to our project's impact on her solar system. My client initiated a shade and shadow study, which, as Mr. Vu had mentioned, calculated a maximum reduction of solar absorption at about 18% in the mid-morning on the winter solstice. In conversation with both Mr. Vu and Mr. Kehoe, we agreed to pay for relocation and/or retooling of the panels affected by our project. In addition, my client prepared a detailed remediation plan offering to pay for an installation of a separate solar system, augmenting the existing system with the highest rated panel technology now in existence. Mr. Bavin of All Valley Solar is here tonight and will speak in a few moments to clarify some additional information on this. In addition, ANR has voluntarily agreed to the following. First, to protect the existing IPE fence along the property line. Second, to spray for termites once a gradient has been completed. Third, to abate potential vermin infestation upon commencement of demolition. And finally, to remove the tree on the northeast corner of the ANR property that would have blocked solar panels on our neighbor's residence. Now, I wish I could say that we have come to a firm and final agreement with our neighbor. We are working as diligently as we can, but I do hope that after all of the cooperation that our client or my client has provided, we would request that the commission move forward in support of an approval tonight. We are here to answer and respond to other questions. I am now going to hand the mic over to Mr. Abramson, who will provide additional input regarding the project. Thank you.
7 minutes, 33 seconds.
Good evening, Chair and Commission. Excited to be before you tonight for this project. Rick Abramson, City of West Hollywood. There's been a lot of discussions about how we go forward as a city. The city's built out, and now it's our charge to think about remodeling the city in terms of adding housing going forward. And so it's something that we've always been thinking about, and the way that we think about housing changes from decade to decade. And where we are right now is in a place where we're understanding cities growing and getting much more dense, but we want to be sustainable in the same way. So this project, I think for me, starts to really heighten that conversation of what's possible when we live closer together, but still environmentally responsible, in an environmentally responsible way. The trends have been to get bigger and bigger with unit size. The city has a maximum average unit size that's attempted to stem this tide, and we're starting to see the unit sizes decrease, even though family units are getting actually smaller and spaces are getting bigger. So the question is, how do we infill going forward? How do we start dealing with tighter lots where we're already built out and have adjacencies? So one way is to think just simply about density. How do we put all the cars underground, go property to property line, and build as much as we can above ground? And that's certainly one path. But I think there's another path that's not just about density, but it's about making cities dense. And by that I mean dealing with not only the environment, but how people interact socially, how we create places that are within walking distance, complete cities that are dense with more housing. And interestingly, the trend, when we ask individuals their ideal of where they would like to live, the perception is apartments and condos are what especially the younger people are looking for, that the home ownership maybe isn't as desirable. But what's interesting is when you look generationally, that's not exactly true. And in fact, over 80% of the population, regardless of generation, ideally would love to have a townhome or a single-family home. So this project actually starts that conversation. Like, how do we create the individual in a collective context? So one thing we could have done was applied for a density bonus, put in one affordable housing unit, and requested a height bonus, built out to the setbacks, and we would have had something like this, up to 39 feet tall, when you include the parapet height above the allowable 35-foot height limit. We felt that really wasn't the way to go here, and instead thought there was some other alternatives. Mr. Vu mentioned the driveway cuts. We looked closely at that, and the one thing I heard from the neighborhood previously working there was that street parking was a huge issue. And so we took that into account. Also, their desire to avoid these large single mass developments, and instead we're proposing what's on the bottom of the diagram here, which is a separated series of individual townhomes, each with their own green space that serves each townhome in the ground, where canopy trees and vegetables can be planted and gardens can flourish. We felt this, for the context, fit really well. Scale-wise, we were reducing that 39-foot height down to 22 feet. We sloped the roofs adjacent to the north property that had the solar panels to be very sensitive, reducing the height by up to 17 feet. We also voluntarily set back on the side yard. The requirement is 5 feet, and we're set back at 7 and 8 feet. The upper level is set back different than the ground level. So we have an additional side yard setback, a lower height, and a sloping roof, all of which allow greater solar access to the neighboring property. The parking I mentioned also was something that we were really excited about going into this design and considering different patterns for the development. We found that with this one cut of the curb, one driveway, we actually can add 3 new parking spaces to the street. That's something we didn't even anticipate. We didn't want to lose parking, but to gain 3 spaces on this street was really something we were very gratified about. And of course, the green space in this development pattern is so different than you would get in an underground parked apartment or condo building. We're able to achieve well over 2,400 square feet of green space and exceed the requirements for open space in the code by 400%. We've gone from a little over 1,000 to a little over 4,000 square feet. It's a development pattern that makes a lot of sense, where you can house more people in a dense way, but really responsive. So the request we have in terms of the variance is respect to the front yard. On the image there's a blue line that indicates where the sidewalk edge and the property line is. On the left is the 2 parcels that are just to the south of the property that we're looking at. Both of those properties are built way frontally, and in fact at 12 feet, which is our request, we would be about a foot behind that white, those double porches that are on the image there. So we don't feel like granting the variance would create any impacts, and in fact would actually be more cohesive when you compare it to what's adjacent. You've already seen the images, so I'm going to just flip through these really quick. And I would close with one quick request that we would like you to consider relative to the front sidewalk and parkway. This was something that we had asked of you in the previous Hilldale project. There's a sort of inconsistency with our sidewalk standards versus the physical streets that we have, and we would just request that you would add to conditions 6.3, 6.8, and 6.14 some language that gives discretion to the Director of Public Works to work with us on the frontage along the sidewalk. I think that language would just open up a conversation about how best to finish off this particular stretch of Hilldale. With that, I'll close, and then happy to answer any questions if you have any. Thank you.
Thank you. That's a great presentation. Commissioners, do we have any questions of the applicant at this time? No?
Okay, thank you.
Thank you. David, do we have any public speakers?
We do. Our first public speaker will be Christina Kropp.
Okay. You have 3 minutes. Please state your name and... Okay. Sorry, I'm being asked to do disclosures at this time. If you'd mind just waiting a second.
Absolutely.
Commissioner Erickson?
I met with the applicant and discussed items pertained in the staff report.
I had a brief phone conversation with the architect regarding items in the staff report.
And thank you. I had a meeting with the applicant's representative, and the architect, and we discussed only items that are in the staff report. That's it.
Thank you. I visited the site and spent some time with the context to understand the project.
I met with the applicant and discussed items contained in the staff report as well as their presentation this evening, and I also visited the site.
I met I met with the applicant's representative, and we discussed items contained in the staff report.
I visited the site, and I also had a meeting with the applicant's representative, and the architect, and we discussed items contained in the staff report.
Thank you. Ms. Kropp.
Christina Kropp of Luna and Glushan here on behalf of Ms. Osterhofer, the owner of the single-family home next door to the project. We have expressed many concerns with regard to this project, and in particular with regard to the solar ordinance. The solar ordinance that the city has provides that a structure shall not be constructed as to obstruct the solar absorption area on a neighboring parcel. Only if the owner of where the property, where the panels are located, agrees, can the city impose a condition that the developer who's going to obstruct the panels be willing to pay for reasonable relocation costs. As I stand here before you today, we have not achieved an agreement on this issue. So I want this Planning Commission to consider the condition that the Planning Department is asking you to impose. The proposed condition that subsequent to project approval, all of the details of remediation be to the satisfaction of the Planning and Development Services Director is setting a dangerous precedent. My client will have no input at that time. The solar ordinance is unlike any other ordinance that the city has. It requires action by a third-party neighbor. It requires agreement by a third-party neighbor. How can this commission okay a condition that essentially gives the developer and the city's Planning and Development Services Director the right to come up with a remediation plan that will go on my client's property at a time when she essentially has no more voice to express her concerns? The remediation plan that has been submitted to you, that has been submitted to us, it's not firm, it's not final, it provides for options. We can do this plan, if there's not enough room on the roof, we'll do this. If there's electrical limitations, which we're not sure of yet, we can do this. It's not a true concrete plan. And yes, we're working with the developer to come up with those details, But today, we don't have that. And we are very concerned about the precedent that the city would set if this type of condition were approved that would allow the developer, again, and the city to come up with what plan they thought fit and essentially force it upon my client. I work for developers and neighbors all the time. I know developers. I know they wanted this approval yesterday. I get it. I totally get it. We're not here to delay because we want to delay. All we want is a voice in getting a remediation plan that works for everybody. And so with that, all we ask is for this to be continued. We've been working with the applicant. We believe we're almost there, but this remediation plan was sent on Friday. It's not been a week. The T's are not crossed and the I's are not dotted. Thank you.
Thank you.
Question. Did you say that the plan was presented to you on Friday?
Correct.
Last Friday?
Yes.
Thank you.
Have you had any solar expert on your end do any plan or give you any input?
Yes, absolutely. And that's actually one of the options that we're considering, whether to use All Valley Solar or whether to use our own solar engineer. And again, we're just kind of trying to work that out with the developer, and we're not there yet.
And what's it going to take for you to get there, do you think?
I was hoping a week, maybe 2 weeks. This is not rocket science. I'm not a technician, I'm not a solar engineer, but I'm being told by our solar engineers that this is doable. It needs to be put together, and it's just not yet.
And have you thought about what might happen if we didn't put into the conditions that they remediate, and we went along with planning with the concept that the Planning Commission could modify it if they find that its strict compliance would unduly limit property development or interfere with the development potential?
With all due respect to staff's presentation on that, I think that's quite not thought out. That the concept that just because they proposed a project and to comply with the ordinance, they would have to take the project down, therefore it unduly interferes with their rights to build a project, would mean that any project that ever blocked solar panels would be unduly burdened if they had to modify it.
Have you done your own study, though, to figure out just how much interference it would be with the electrical system?
Yes, and we agree with their study. So that is.
So you're in agreement with the study?
We agree with their study. What we don't have is the remediation plan, and it's just a matter of timing. It just hasn't been. It was just presented. It was not presented as a final plan, just as a series of options that would still require somebody to come to our property, look at the electrical panel. We're almost there. But we're not.
So what you're asking is a continuance of the item so you can work out your agreement?
Essentially, and then you don't have to see
Another
me again.
week or two, or?
I'm here, our lobbyists are here, their lobbyists are here. We know everybody, and everybody's just looking for a resolution.
Okay,
Truly.
thank you so much.
You're welcome.
So, excuse me, as an attorney, how would you modify this language to address this issue?
I don't think that you can. I think this issue needs to be resolved before a planning commission takes action. I think the condition is like a Band-Aid on, my leg being chopped off. It's not going to work. The way the solar ordinance is drafted, I think you need to have the resolution be firm in order to comply with the solar ordinance.
Okay, thank you.
You said something that your client's voice would be taken away. The courts are always available to her. It seems like she has a lawyer. So could you further explain that point?
Sure. So the condition as written says that the remedial plan would have to be to the satisfaction of the Planning and Development Services Director. Okay. So the developer presents a plan to the Planning and Development Services Director, and the Development Services Director either says yay or nay, or I want conditions, or I want changes, and those two entities are now discussing what's going to go on my client's property. without my client's input whatsoever. And if I sued over something like that, a court would simply tell me you needed to challenge the condition. And that's what I'm telling you. I don't think you can impose a condition like this. The court's not going to step in and say the Development Services Director made the wrong call. I'm just saying it takes the solar ordinance as drafted requires a third party. I know there's very few ordinances like that, right? And you have a development, you always have conditions to the submit a grading plan to the satisfaction of the grading department. It's always about the developer's property. This particular condition includes a third-party private property owner who's here willing to work with the developer in this particular case, and we have been. It's just timing ran out on us.
But you can appeal.
We certainly can. But
Right, so
but
I'm
that would
just,
delay.
you said your client's voice was being taken away, when I don't think that's an accurate statement, because she has options before her. She could use the courts, she could appeal this body's decision if it were to make something. I just am worried about the type of language that was being used.
Fair enough.
So.
Thank you.
Thank you.
David, was that our only public speaker?
No, our next public speaker will be Ted Bavin, followed by Edward Levin.
Thank you.
Hello, I'm Ted Bavin. I'm the owner of All Valley Solar, and I was hired by the applicant to come up with a remediation plan that would offset the loss of electrical. I've been a solar contractor for 33 years. I am a solar zealot, and I've supported all laws that defend solar, such as your ordinance. So when I was contacted by a developer to offset the remediation, I was thrilled, because that's exactly what I did. So I studied the shade report done by others that was accepted, and was able to design a system that would have literally no impact on the neighboring property. And I want to assure you that that's what my intention was, meaning we are replacing existing panels with much more powerful panels, 415 watt instead of 285 watt panels. They take only an inch or two extra room each. So, we're only replacing either 7 or 9, depending on what I see on site. I have not been on site, but I have the contracts from the original installation. I know what was there. I know what is there. I know how big they are. And it's going to work beautiful, and it will more than make up. I looked at the shading analysis, and I took the most extreme possibilities. I maximized the effect of the shading, and then figured out a way to offset it by putting in more powerful panels. Yes, there were a few options, but that's just to cover myself, that we don't know what, we know we can do it. What I don't know is whether we'll have to replace all 16 modules that are out of the shade, that are completely in the sun, or whether we can do 9 and the neighboring property will come out ahead. That was my goal in this remediation.
Question.
Okay.
Sir,
Yes.
you've been in this business for decades, correct?
Yes.
How many times have you come to this kind of an impasse, or any kind of an impasse, where you make not decisions, but you make offerings of solutions where you don't even go to the site?
This is frankly the first time that it's actually come to this
You've
level.
answered the question.
Yeah. It's fairly new law, fairly new situations where people want to build buildings next to existing solar systems.
Thank you, Mr.
You
Bavin.
think it's possible to solve the problem without even looking at the site?
Well, I know this solves the problem. I know it offsets the electrical. That I know. That's nuts and bolts.
In other
I
words,
would- never mind.
in other words, you don't have to actually be at the site. You can look at the architectural drawings and all that, and,
Oh,
be able-
yes.
and shade and study, and you can make that determination.
Sure, satellite views, photographs. I know exactly what angle the panels are at and where they are. The only thing I haven't seen is the actual electrical panel. But again,
no matter what I see there, I know that it will work. Just a
So
matter of
before you would actually install the panels, you would go to the site and make sure that whatever you do is going to be more than adequate?
Absolutely, and of course have approval from the owner. I mean, that's.
Right. Well, you'd have to have approval, or you wouldn't be able to access the
I can't
property.
go on the property.
Yeah,
That's right.
exactly. Thank you.
And you're doubling up, you're going to a 415 watt instead of a 215 watt, you said.
Correct, and it's just replacing module for module.
Yeah.
Not taking up more roof space, not making any holes in the roof, no negative impact.
So the existing solar panels are producing less amount of, a lower amount of energy than would be in the remediated amount. Thank you.
At the time they were bought, they were a fairly low wattage panel, and of course things improve over time. The 8 that are there, the real option here is that the 8 that are in the shade, there are 4 that are very shaded, and there are 4 that are partially shaded in the winter, only in the winter really. And so what I don't know is whether I can just leave them there and replace some of the ones that are in the sun. If I can't leave them there because of some electrical limitation, then I have to replace both rows to make up for it properly. That's the only if, and, or but. It's no question that it'll work.
Thank you, Mr. Babin.
Thank you.
Mr. Levin, followed by Aaron Nussbaum.
Thank you, Chair, members of the Commission. Edward Levin, resident of West Hollywood. I'm only going to speak very briefly about the project itself. It's beautifully designed, and it's I think, a remarkable model for sustainable density in the R2 neighborhoods. I do want to speak a little bit about the solar, and I want to leave aside the fact that the existing neighbor's solar array is the worst I have ever seen in terms of how it's actually laid out. But what we're really looking at here is an ordinance that is in serious need of clarification. When we look at a project, we do a preliminary evaluation of the traffic. We have a preliminary analysis of it, and based on that, it is either above a threshold or below the threshold. If it's above a threshold, we do a traffic study. If it's below, we don't. Whether the neighbor wants one, whether the neighbor's attorney wants one, we don't. We have thresholds. We need this for solar. We need this for shading of solar panels. We need actual criteria, and we need actual thresholds that the city staff can enforce and decide whether a study is absolutely needed or not. This study demonstrates that you don't need it here. Anyone with a brain can look at this, can eyeball this, and know that there is just an absolute de minimis impact on the neighboring property at the winter solstice. Frankly, max cooling load is at the end of August, beginning of September, which means you can do a study at the equinox and know what effect this building will have on the neighboring solar panels, and it's essentially zero. So the idea that we're sitting here and that we have delayed this project for months over a solar study has serious impacts. It has serious impacts for the developer themselves in terms of the cost they bear, but it has serious social impacts as well. We have a housing crisis here, and if we keep delaying projects, and you're now asked to delay it again, if we delay project for 3 months and then say, well, what's another month, what's another few weeks, this means that that this building will come online. We will have this housing built 3 months later, 4 months later than it otherwise would have been. We cannot keep doing this and delaying projects for what are clearly unnecessary environmental studies and unnecessary studies of impacts, which in this case are just absolutely minimal, as you could clearly see from the solar study. We need real criteria for, just as we have for traffic, for when we do studies, what the nature of those studies are, and how we do them. We really need that, and this is the clear example of why. Thank you.
Thank you, Mr. Levin. Mr. Lester? No?
Good evening to you all. Thank you. It's an honor to be here. My name is Paul Lester, and I come to you as a resident of West Hollywood. I live about a block and a half away from this project. and I am in favor of it. In full disclosure, I'm a realtor here in Los Angeles. I'm one of the partners who started the agency in Beverly Hills, but I come to you as a resident of West Hollywood. I've been here for about 18 years now and living on Cynthia Street for that time. I thought I would provide a fresh perspective and simply say that it's nice. I've been involved in quite a lot of these projects throughout Los Angeles on my own time, and it's very nice to see something that is sensitive and well thought out, beautiful, provides a lot of the elements that we'd all like to see in our own homes in new construction, and I find that refreshing. So I come to you as a resident of West Hollywood, not as a realtor. So thank you.
Thank you, sir.
We have one more that just
All
showed.
right.
Sir.
Hi, good evening. I'm Elmore Gerlitos. I'm a resident of 932 Hilldale. I have a question whether the developer or anybody here can tell me if there's a construction mitigation for this project. I'm concerned about, workers probably leaving their trash or using whatever little parking we have left there. More importantly, is there a parking area that you have assigned for workers while the construction is going on? That's it.
Great, thank you. Now's the time for applicant's rebuttal. You have 5 minutes if you'd like to address some of the questions and comments made by public.
Mr. Chairman, I'm going to, again, be brief. I know that Mr. Augustine Rodriguez, who is the managing partner at A&R, would like to speak for a few moments. There are a couple of items that I want to be sure is made clear for the record, and Mr. Vu may be able to help me with this. We have been told that the condition, this is condition 2.6, is not precedent setting, and that the city has in fact used this condition on other projects in the city. Also, in relation to using our engineer or using our neighbor's engineer, we have made it very clear to council that that is our neighbor's option. We will support using the neighbor's engineer if that's what she would like to do, or we are more than willing to allow Mr. Bavin to do what he needs to do, and we still believe that that is the more efficient way to go. That's where we are at this point. In regard to the question about mitigating on construction, I know staff could basically say there's a construction mitigation plan. It's very specific and detailed in relation to vehicles coming in and going out, and we are more than willing to live with those conditions as set forth in this approval. Mr. Rodriguez?
Good evening. My name is Agustin Rodriguez. I reside in the city of LA. I am the developer for 917 to 927 29 Hilldale. First of all, I want to thank you for reviewing our submittal package. And I've been developing for nearly 30 years. I've developed from affordable housing to luxury mansions. So I'm used to dealing with sensitivities in neighborhoods and dealing with issues that affect neighbors. I've been more than committed to address all of the issues concerning our neighbor to the north. I am not a solar expert, so what I do is when I don't know about something, I hire someone that knows what they're doing, that they can help me assess the situation and make it better. I do feel that we have gone above and beyond to whatever our responsibility is. You know, initially there were only 4 panels that were affected. We went above and beyond, and our consultant recommended, well, we need to replace more. I said, look, do whatever it takes to get it done. We will replace the whole system if we need to. So at no point in time, we're trying to back off from our responsibilities to correct the situation. I'm here to develop this beautiful development that Mr. Abramson has designed. And I build high-quality homes, and I want to do the same. I'm consistent with the type of product that we put out, and I am very concerned about neighbors' needs. But I also think that there's a point where we've been negotiating for months. This just not happened Friday, sir. This has been going on for months. We've offered every potential alternative. We have gone to responding to their requests. Whenever they come in, we bring someone that specializes in that concern to address them, you know? There are many other conditions that they have put upon us, and we've accepted them all. So it's not like we're trying to build this townhome project and obstruct their view and run away. I mean, we're here for several years to build this project. We're here to stay. So with all due respect to the neighbor, you know, we are not trying to minimize the amount of responsibility that we have. We're very confident with the conditions set forth on the conditions of approval, that there's a body that enforces that this is all done to the requirements. So, thank you.
Thank you.
I have a question for the applicant.
Sure.
Okay.
If this condition 2.6 were to be modified to effectively remove all the caveats and the reasonablenesses, et cetera, and to simply state that the applicant will pay 100% of all costs required to maintain the current productivity or better of the existing property, would that be satisfactory to you?
This is one of the reasons why I hired Mr. Ted Babin, because I wanted to understand the current performance and the existing performance of the system and how can that be improved. So like I said, I've offered to do whatever is necessary to keep the neighbor satisfied. I do think that I can't guarantee any of the systems. I don't know. In fact, I'm very new to solar, despite the fact that I've been building for so many years. But I am being given the confidence and the assurance that whatever systems they will install, our consultant, that they will supersede anything that they have installed. To answer your question is yes.
My question is, my question is, would you be willing, if we were to propose modification of this paragraph 2.6 to remove all of the caveats and reasonablenesses and staff involvement, et cetera, to simply say that the applicant will pay 100% of all costs to maintain the existing productivity or better, would that be acceptable to you?
Yes.
Thank you.
Well, exactly. We will make sure that anything that gets installed on their property is fully functional, and all the guarantees and warranties that are offered from a solar company are in place. I cannot be held responsible for a system that I didn't install, for the performance of a system that, you know, these systems tend to degrade, as we've seen. Their system was installed in 2016. We're already seeing some degradation in the panels that they have installed. So it's typical that those systems become less efficient. What Mr. Babin has provided is a newer system that has longer performance, better performance, and longer duration on the overall system.
I have a question. I guess I'm hearing it's almost done, it's done, we've been talking about it for months. What's left? I mean, like, it sounds, I'm just really curious about, like, okay, so what is the final sticking point between you and the other side that's not, because I do hear this does not just happen on a Friday. Like, you talk about this for quite some time, but, like, so what's left? Like, do they want, what do they want that is the, I don't know if I'm phrasing that correctly, but maybe I am, but.
We have to live up to a confidentiality agreement. So I can't really go into detail, but I can tell you that the primary issue has been and continues to be those 8 or 9 panels. I can also tell you, Commissioner, that the warranty that we have our engineer initiating is a 25-year warranty on SunPower panels, which I use in my house. And to my knowledge, we entitled the SunPower solar array at Occidental College campus-wide. It is still the finest solar system that is made. So that's where we are.
So are you representing that the system that you are proposing to install and replace the current one is substantially more efficient, more effective, and has a longer life expectancy than the one that currently exists? Because you use the word that it's degraded,
Well,
that there's been some degradation already on the panels that are existing now?
Commissioner, we're talking about augmenting her existing system. We're not creating a brand new single system. I can't speak for the system that's there now. I can tell you that wattage-wise, degradation of the panels are significantly greater than what we are proposing. I mean, I know the system that we're talking about, and the technology in the 15 years that we installed it at our home has been dramatic.
Commissioner Elchel?
You come here today with some of your representatives, some of your staff, some of your team, and some of the public screaming about how long this has taken to get to this point, and yet the owner of the property next door with the solar system has only had 3.5 business days with which to look at your proposal, and we have had about an hour to look at your business proposal, if that. What is this business? Why is it that you're complaining about how long it's been taking?
Because it has been taking months. This is not just initiation of one program or one option. This has been going on for months. We have been in conversation with our neighbor. Mr. Handelman invited us with Julia into their home 3, 4, 5 months ago. The 4 options that I had talked about in my initial study, that came from that meeting. So this has been going on much longer than 3 or 4 days.
Well,
and forgive me. And the plan that we had submitted was submitted last week with the idea that it's very detailed, but we believe that our engineer, because of his experience, has provided as a great an option as we probably can give you.
Can I also add something to that, to answer your question? We, in essence, decided that we needed to hire our own consultants after the shade and shadow study to determine the productivity of their system and come up with solutions, you know? We were hoping that the neighbor will provide information from their solar consultant of what studies they've done. Nothing came from them, so we took it upon ourselves to hire all these consultants to come up with some sort of form of remediation, you know, and that's after several discussions and so forth.
So the dragging out has been a little bit of their side and a little bit of your side. And here we get to this point, and we're expected to come to the conclusion that you've been disadvantaged because it's been dragged out. I don't get it.
No.
I don't get what
Can I ask, the report that you gave to the neighbor on Friday, does it reflect the information that you've been discussing over the last few months, or is that part of your end?
Yes.
It does. So it's not new information. It was just a
Correct.
summation of the information that you've been reviewing.
Yes.
And part of that report includes reference to the original spec of the solar panels and the spec of the new solar panel and the efficiency of the newer solar panels.
Yes.
Great. Any other questions?
I just want to check with the neighbor because I thought when I asked the question, did you have your own, can you come up, the attorney, please?
I'm sorry, but that was an outright lie. Nothing.
Well, I want to ask you something.
Was in our
Excuse me, ma'am.
discussion.
I called you up because I want to ask you to make sure I understood you correctly. I thought that when I asked you if you had your own expert. You said no, but you agreed that the information provided, that you didn't have any objection to it, that you agreed that it was adequate.
That's incorrect. We did have our own expert. They hired an expert to do a shade shadow analysis. We wanted to have our own expert review the information in that shade shadow analysis. We worked with Mr. Doug Vu to get information from the applicant to do our own shade shadow analysis. That information was not provided. We had to hire an expert to build our own model based on plans, based on specs that were not provided, but that they had to do our own expert
Well, that's
study.
how it usually is done. Each side sort of does
It
their own.
usually is not done like that. Usually the information that they base their study on is shared so that the experts don't have to redo it and they can just check the conclusions.
No,
Okay,
that's
thank
not
you.
how it's done. You usually hire your own people. That's
We did-
standard practice,
right.
pretty sure.
We hire our own people.
And
but
then you
the
do your own
informa-
study.
Yeah, but the information that
And then they
base
do
it
their
on-
study, and then you look at the
but they
differences.
share. I've never had someone refuse to share information.
Well, the information's in the report.
It wasn't.
It's all public.
You can confer with staff. He also asked for the same information to be provided, and I have in an email from him twice that they refused that information.
Okay, thank you.
Thank you. Okay, so we need to close the public comment.
have a
But we'll keep
question.
the public hearing open in case there's more questions. Likely will be. So we'll start commission deliberation. Commissioner Buckner
I have
has
a question for legal. Okay. So we're putting in this condition for approval 2.6, and the neighbor has to go along with it, or what's the point of putting the condition in there? Because, so what would happen if we just pull out the condition and don't do anything about the panels at this point? I mean, they're volunteering to pay for it and put it in and so forth, but the other side's objecting. So where does that leave us?
This is an unusual situation, and I think as Ms. Kropp pointed out, it's an unusual statute, it's an unusual rule, but
Right.
Here's how I see it. You have a rule that a structure shall not block solar panels. Then you have an exception to the rule, which is if the review authority, you can modify this requirement if you find that strict compliance would unduly limit development or unduly interfere with development potential as we've envisioned in our general plan and our zoning ordinance. So what's envisioned for the site? If it's unduly limited by making the project come down to protect the solar panel, you can waive that rule. Then as a third element of this rule, it says, if the neighbor is willing to relocate, you have the discretion to require the developer to pay for that. So it's our offer to the neighbors that, you know, sometimes you're gonna have neighbors that don't agree on something, and this is how the city deals with it, by saying, developer, you have to pay for it if the neighbor will agree. So there's an option that you don't require anything.
Right.
But I do think that this condition can be revised to get to a place where everybody's comfortable. I think the developer's trying to solve a problem. I think the neighbor wants to have a voice in that solution, and I think we can find a condition that
But
gets us
can we
there.
prove it without actually expressing it as part of our decision tonight?
I think the issue has to be addressed. It's been surfaced. I would definitely look to legal for a way, to my earlier point in question, as to how can this be amended in a way that addresses all parties' concerns, and in particular, makes it less flexible, if you will, that really says this will get done in a way that's satisfactory.
Or could we add a condition that the parties resolve and that we have a report on it in like a month and then bring it back to make sure that the conditions of approval are being met and that the other party that their terms have been met, or there's an agreement that's been mutually agreed to has been reached? Is there something else that we could add?
You know, I wouldn't, once you've given an approval, you've given an approval. So I wouldn't put a condition that it has to come back, and if they didn't get there, then we would hold back on that approval. I think we should resolve it in this resolution. Ms. Alcar came up with some proposed language that might.
Can I, before you say that, Jen, the reason why I asked the applicant my question about, like, well, what's left, right? And there's a confidentiality agreement, it's fine, whatever. I feel like something's not being said here. I don't even think they're talking about the solar panels in this agreement. Like, I think that's a done conversation. It sounds literally like you said, we're going to give you brand new solar panels that are going to produce double the amount of what you have now and make your life great and dandy, and you can get all the solar energy you need. And then we're discussing this issue, but there's something that's not being said, and I understand you can't talk about it, and that's fine, but we're making a big deal out of this issue when it sounds like it's been solved, and the applicant has gone through very good faith efforts to address this number one issue. Because if the number one issue was solar panels, this issue would have been done weeks. Also, like, in 2016 and through 2018, Governor Brown was on a solar panel kick, and he signed multiple pieces of legislation. So, like, I have questions about the owner of the house. Like, did they get these? Is it a tax sweep? Like, how, has the applicant actually put forth a lot more substantial money to replace something? I'm going on a tangent here, but it just seems like that's not the actual issue that we're actually trying to talk. They can't actually talk about the issue that's actually causing the conflict. I don't know.
Well, that's why Commissioner
Jennifer's
Huppengartner,
language.
yeah, recommended language that if it's a little bit more precise with a little bit less discretion, it might be a reasonable compromise for both sides for our purposes, and they can work out what they need to work out. Do you want to read the language? I came up with some language that could just add consultation with the neighbor, but I actually think what Jennifer came up with might be a little better.
So what I did was I took what Commissioner Huppengartner was talking about. I think I'm going to read this, and then I want to just say one more thing. So the condition would read, prior to issuance of certificate of occupancy, the applicant shall pay 100% of the costs associated with relocation or augmentation of the solar panels at the address, such that the energy generation is commensurate with existing function at the time of installation. So that would keep it from being an issue of having to maintain that level of energy generation. I think that was a concern that I heard. Also, the work would need to be done at that location of the next door neighbor, and in order for that to happen, there would be building permits involved, of which they would have to sign off on them. That gives them an opportunity to just be part of the process at that point, but it needs to happen. It removes the language, like Commissioner Huppengartner was saying, that gives them an out. So the work has to happen. The owner of the property next door needs to sign off on it, and then it's a set time when we measure the energy generation. So that should hopefully remove some of the concerns that were associated with it.
I like it, Jennifer. My only caveat would be that having it done by C of O, that sun blockage will have been happening for quite some time during the course of construction because the building will have reached its full height. So I think the timeline should perhaps be changed.
Issuance of building permit?
There you go.
I have a question as well with the language. When it says 100% of costs associated with this, obviously that would be the new solar panels, but would that be another consultant? Would that be putting in a new roof if that's needed? Would that be the dog sitter when the construction work is going on? I'm intentionally going ridiculous on this, but like I think that language is so broad, 100%. I mean, we're buying somebody a new house maybe. I don't think that language works.
And that's where the reasonable costs associated came from. So I deliberately took that out, but we could always introduce that word back in.
Well, I think reasonable ancillary costs to getting this accomplished is something that should be included in that. And I think that the attempt, or what seemed to be the attempt here, to take away the neighbor's voice in this situation or cooperation in this situation is bad and wrong.
I mean, absolutely, there has to be sign-off from the neighbor. I mean, and the neighbor's attorney is correct. I mean, the neighbor has lost their rights in this language. So I'm trying to find a way to make this a win-win and get the job done in a way that protects everyone's rights.
So are we saying that that language is not something that we're comfortable with? Or that we are?
I don't feel like it.
Yes. The reasonable ancillary?
I'm not comfortable with it, and I have reasons I want to speak to that, but I just wanted to get the clarification around the 100%.
Okay. I think, I don't know if this is even appropriate. Are we allowed to ask of the applicant and the neighbor how they feel about the language? Because I think the idea is that we want to build consensus here and make a decision that everybody feels good about, right?
You
So
left the
can-
public hearing open, so you could
I defer to
continue
Chair,
some
but
comment and ask some questions. We want to get to a resolution for everybody.
Could we
so
have
I-
Jennifer just reiterate it before we ask that question of both parties?
it
I
out
think that
loud,
would be
please.
helpful.
So we would be adopting a new paragraph 2.6, and
Yeah,
this would
it
be the
re-
language.
It would replace the 2.6 that's in your packet. It would read, prior to the issuance of a building permit, the applicant shall pay 100% of the reasonable ancillary costs associated with relocation or augmentation of the solar panels at the address such that the energy generation is commensurate with existing function at the time of installation.
Existing or better than.
Yes.
Would it be appropriate, it would be appropriate, but do you think it would be something that would accomplish what we need if we take a 10-minute break and have the parties confer about your proposed language?
The only thing I would say is you incorporated John's ancillary language. But I think there was actually, there's the primary costs of the panels, and then ancillary costs would be the studies, et cetera.
Addition.
So I think you need to incorporate both pieces. Otherwise, it just sounds like you're just going to pay for a separate consultant and not the actual getting it done.
Sure.
And I believe it should say reasonable ancillary.
And does it, I maybe didn't hear it, does it include that that both parties have to sign off on the permit?
That's just part
To
of
get
getting
the
the building
permit, yeah,
permit
so that
for the
both
solar
parties-
panel work. Yes.
And it has to be within a certain amount of time? So
It has
that-
to be prior to issuance of building permits.
And what if that gets delayed months?
Then they wouldn't need to have any remediation because the building would not be being built.
Why don't, I kind of like Commissioner Alschel's comments. I think the language has been worked out, and I think it would be good for the parties to discuss, frankly, and see what that is. Because we also haven't even weighed in on Commissioner comments on the actual project itself. So, just saying, we have a little bit longer ahead of us. But I think that because it seems like that is like the number one issue, I think it would be great to get that out of the way and before we go into commentary on the project.
minute break and give-
I would, if, I know it's not an emotion, but I'm agreeing with Commissioner Alschel that I would like this problem solved.
if they
And we're-
need 10 minutes to confer, I'm
2
sorry.
We're
Regis.
okay to take a 10-minute break then? And
Yes, but I'll just admonish the commission that the public hearing is
talk.
still open, so not to talk about the item
Can I-
amongst yourselves, and the public shouldn't come talk to you about it during the break.
Just before we break, because it is about the solar panels, and this, I looked up the code. I'd read it when I was studying my packet, but I wanted the language familiar to me. We've been talking a lot about the first sentence of that particular section that says that the solar panels need to be protected, but the next sentence says the review authority may modify this requirement. And I think that's where we're really getting into here, is I think that there's been these discussions, and I believe that we've determined that we can modify this requirement if it's going to impact the ability to develop this property. I believe that's our discretion, and the code specifically says it's our discretion. So I think what we're saying here is very clear to both parties. We want this to be worked out, and I think our staff hears this. That's why I support 2.6 exactly as it is, because it's telling our director, we want this worked out, but then he'll make that decision based on that. So before we, before the parties go and deliberate, I want to make
Working
that
with
clear.
both parties, because
course.
the, not
But
the
I trust our
non-app
staff would do
miss.
However, we are going to make a decision on this project before the evening is over, so.
I mean, buckle up. I mean, but but because, and Adam is right in stating that because Katie, what was your name? Christina, don't know where I got Katie, sorry. In stating that you said your client's voice was taken away, I think Adam's intent in reading that second line shows that the planning director, the authority, would essentially reach out to both parties to get that to be an understanding. Lynn is shaking her head no, but maybe I'm wrong.
Because there's no reference to the third party in this language. There, yes, it would be the intent, obviously, that Mr. Kehoe and friends would have a conversation and work to negotiate this, but the words we are approving does not state that the neighbor has any protections here whatsoever. And I think that's a valid concern, and that's why I made the recommendation that I did.
All right, we're going to take a 10-minute break then.
Okay.
Thank you.
Oh, I guess they're fine. I'm going back for Thanksgiving. Oh, that's good.
So 10 minutes has come and gone. Do we have something yet? Jennifer, how much more time? Okay. So would the app?
I'm a little concerned with that language because...
Jennifer, could you maybe just read the new proposal to us so we can just all reflect on it? Thanks.
So Chair, you want me to read this? Okay. So the new condition 2.6 would read, prior to the issuance of a building permit, the applicant shall pay 100% of the primary costs and any reasonable ancillary costs associated with the relocation and/or augmentation of the solar panel system located at 931 Hilldale Avenue, such that the energy generation is commensurate with existing function at the time of installation.
I'm a little uncomfortable with the applicant paying 100% before they even get a building permit. Who are they going to pay it to? They're going to pay for it and then they'll get no building permit? That doesn't, there's got to be a different...
The direction was that we wanted to have the taken care of prior to them starting construction so that they would not experience any gap in energy generation. So it's up to the commission.
Here's a potential solution to this. Prior to issuance of the building permit, they will agree to pay 100%, and that will have been defined, what that amount will be. And then the actual payment of it will happen prior to X phase of construction. The actual
That's workable.
completion of the doing of the work and the paying of the work happens prior to, you know, the
Commencement of
getting to,
construction.
you know, anything, any height of the building that is in parallel with the building next door, or some phase
Or framing.
of framing, exactly.
Completion of framing
Exactly.
potential? Okay, so the issue that I have that's a little worrisome is, what if the neighbor decides not to sign? What happens then?
Thank you, Chair. I was thinking along those same realms, and I apologize, I might be going back to square one, but can't we just approve with direction to resolve within 60 days, or the neighbor gets nothing?
Yeah, I think that's...
I mean, I thank you, Jen and Doug, for doing all this, but I'm going back to what Adam said, but I've been thinking about this, and so I just wrote it down: to approve with direction to resolve within 60 days, or the neighbor gets nothing. I mean, this issue is not about solar panels, in my opinion, and they need to come to an agreement on this. It seems like good faith has been made on the applicant's part, well over good faith if I have to be judgmental on this. And we need to come to a solution. And so I think the solution is to empower both parties to come to a solution within 60 days, or that's it.
Can we ask the applicant and the neighbor, were they able to debate this or discuss this during the break? I mean, that was the whole purpose of the break, right?
This was the language that came out of the conversation during the 10-minute break, correct?
This was the language that came out of the commission's discussion.
And did they agree that this is good? They're happy with it?
We'll have to hear from them.
No, because they
This is
needed
the first
to.
time they've seen
They're
this
seeing
language.
it now. right.
Okay, so, but we still have issue with the language. So they're going
I
to have
think-
question with the language.
Well, I guess I just want to say, like, if the people, the involved parties are, like, okay with the language, can we be okay with it too? I mean, I just am, again, like, trying to figure out a way that we can, you know, make a decision that people feel good about. And if they both agree that they're okay with the language or not, then we can, you know, move on with our discussion or figure something else out. But I guess that's why I'm curious, if this is something the parties would be agreeable to or amenable to.
How about everyone comes up to the podium so it's
Yeah.
reflected?
Applicant, would you? Yeah.
Well, we want to make sure that the applicant and the neighbor are good.
You're willing to pay 100% of the costs before you get a permit? Or are you agreeing to pay 100%? It says shall. That's a strong legal word.
I'm George Jordan. I'm one of the principals of A&R Development Company as well. I think the discussion that the commission had regarding the modification of this language about agreeing to pay and then paying prior to either completion of framing or starting of framing is acceptable to us. At any point that the construction would, you know, be at the level where it could potentially impair the shading and shadowing.
Okay, so given that, Commissioner Hoopengardner, are you okay with that addition?
I'm fine with that. I think
Okay.
that's, I wanted a cutoff, so I like your suggestion.
Okay,
Thank
great.
you.
And I'm also in favor of Commissioner Erickson's addition of putting a 60-day response time to this, because we don't want the project held up arbitrarily.
May we ask the neighbor too?
Yeah, can the neighbors representative
representative.
come to the podium, please?
We're fine with this, actually. Thank you, Commissioner Hoopengardner. This is kind of what we were looking for. May I just get clarification on the additional language that we're asked? Essentially that the work be completed before framing goes up? Is that the? Or
When framing is
we will even
completed.
agree, well, I don't know if this is important, but we will even agree that we will agree to have the work done before framing goes up. I know nobody, or maybe some people don't believe, this really is a solar impact issue. So we have no intention of saying no to the remediation. So we will agree to have the remediation done before framing.
So I think
Thank you.
if you address the framing that Commissioner Cavallaro, Chair Cavallaro included, the only other, gets picky, but 100% of the cost, but who's determining the cost? So
By third party.
The when pay and all that is determined by the contract with the provider.
I mean, it's been already determined by a third party, correct? That it would be the solar consultant on this is already a third party, so it would be.
I hate to be the contrary person on this again, but I'm going to. And that is, who determines it? Well, the initial condition says the director would determine that. So I think 2.6 is proposed in our packet is actually what makes the most amount of sense.
And that's where I went with just like,
Back to
go back to it, have approved with, I literally wrote it out, so I'm sorry, Jen, you don't have it in front of you. Approve with direction to resolve within 60 days or the neighbor gets nothing. I'm happy to remove the neighbor gets nothing part, but approve with direction to resolve within 60 days, period. I mean, if the commission feels like, I just think that we need to, in regards to this, if we were to go to this, I am amenable to it, or amenable to it. What I'm saying, ancillary, so we say that word again. But I would like a time frame on this, because I think this project has been held up quite long.
But there is a time frame as is defined by
Prior
the
to.
construction of the frame. So it may be, like, there's not like a date we're going to put on it, but it is in theory part of the timeline that would lead toward the eventual construction and finishing of the building.
And we have language that
If they don't sign off, then they can't move on with construction, potentially.
Yeah.
So it's a matter of, we all believe that this is going to happen, but if we're playing this game, then it needs to be fair on both sides. The neighbor has to agree.
And
at
both
some
parties
point
have
to not
agreed.
hold up construction.
hold
I
up the
I understand that, but I think maybe I'm not a lawyer, clearly. But I think I'm being a little optimistic, but I think that it's obvious that both parties want to come to a resolution on this.
Yeah, and we've had both of them say yes at the podium.
Right.
Like,
Can I make a suggestion that Jennifer, work to incorporate the framing language in here, and meanwhile, we move on to the real discussion about the project, and then come back to this at close of the conversation?
Lauren, you have a comment?
And I was going to say, maybe at the beginning of this clause, we could put some language about if the parties agree, then prior to the issuance of building permits, the applicant shall agree to pay the 100%. So they get to their agreement first, and then it kicks in
Then
the
the clause kicks
requirement
in.
that it has to be, it has to be worked out by building permit time.
So
So if
they
they
have
never
to
get
reach
to
an
an agreement, then to Commissioner Erickson's point, the project moves forward, but there's no
They don't have to
payment on
pay
the
for
table.
anything. Yeah.
You mentioned permit.
Building
And but we discussed changing that to
Framing.
completion of framing.
So I think we need to, I like what you just said, Lauren, so I think we need to rework it a little bit.
Why don't we tinker with it
Okay.
while you move on to
Let's
more?
move
When
on.
you're tinkering with it, could you, I'm still hung up, and it's about this, and I would like an answer for this maybe when we come back to it, but I'm hung up on ancillary, and I'm wondering if that opens up the applicant to, I knew I threw out a ridiculous example earlier, but do we define ancillary, or what does that include?
In
Hence
my
the
mind, it means
reasonable.
the building permit costs. There's probably a fee associated with the building permit, so the neighbors shouldn't have to pay for the building permits if, that's what I was
Let me
thinking
throw
by
out an obvious
ancillary.
one here. She has an attorney representing her tonight. Are legal bills part of the ancillary costs of this?
Potentially,
No.
yes.
I mean,
I
I
would
just
say
think that's
no.
where it kind of goes to a larger conversation, and by saying ancillary, we could really be opening up
Well,
a
it says
lot of other
reasonable ancillary.
based on whose determination.
I don't disagree. I mean, one man's reasonable is another man's,
Unreasonable.
yeah,
But you don't want the word reasonable in there, do you?
No.
Yeah.
but it is there.
Okay, so we'll let staff take a stab at the language, and we'll move on to discussion of the variance and modification and the parking reduction, please.
Okay.
Okay. So, okay, who would like to go first?
I can go first.
Commissioner Erickson.
Stacy.
Okay.
I can go first.
Commissioner
So
Jones.
I also just want to note, it is really hard to hear down here. So I'm learned earlier, I'm actually not going deaf prematurely. It is actually, the acoustics in this part of the dais are actually a little poor, so apologies, and I don't mean to talk over anyone ever. It is harder to get people's attention down here, so I'll just start waving my arms. So,
whistle.
aside from this issue, which has comprised the majority of our discussion thus far, there's really only one criticism that I have, and that is that as a general rule, we really don't like anyone who's been commissioned by the applicant to speak during public comment. I know this is a hair-splitting thing. This is our only public hearing tonight. We obviously, always want to make sure people feel heard, but generally speaking, we wouldn't have the solar person come up, I don't think, in public comment. There had been another hearing about a building on Fountain, I don't know, probably 6 or 7 months ago, and someone did that and we shooed them away. So I definitely wanted to hear what he had to say, and Mr. Baven had to say, and it's important, but it's a procedural thing, and I'm a person of principle. This seems pretty clear-cut to me insofar as the merits of the project. We don't get variance requests very often. I am pending the language that staff is able to come up with following. I'm very much in support of approving the project as it is outlined in the staff report. I feel strongly that this developer has gone above and beyond to make a project that is better, not bigger. We don't see that all of the time here. I know that they're asking for a modification for the rear yard setback. I'm inclined to grant that. And so far as the variance for, I'm losing my notes here, sorry. I do take lots of notes. Insofar as the variance is concerned, again, I'm inclined to grant it. The parking on that street, I've walked that street and I've driven it. I don't actually recommend driving that street. It's very difficult to turn around if you don't actually live there, especially if you're headed north. But the addition of the 3 parking spaces, I feel, it's a really beautiful project. I think it does well in terms of incorporating into kind of the fabric of the neighborhood. It's an interesting street. There's lots of different styles there. But I think that the applicant did a good job of enumerating kind of the reasons why this is kind of the best project for the site, and I'm very much in support of it. That was the easy part of I think, at least for me, that will be the easy part of the decision tonight. So I'm inclined to support it pending our ability to create language that everybody up here and the neighbor, who I very much want you to feel like you have a voice in this process, and the applicant, whom I actually do feel has done very much their due diligence and is willing to go above and beyond, and that's recognized and appreciated, but we all feel good about. So those are my comments.
Thank you, Commissioner Jones. Commissioner Altschul?
I agree with Stacy.
Thank you, Commissioner Altschul. Commissioner Erickson?
I agree with Stacy and Commissioner Altschul.
We know that's not all you're going to say. Just keep talking.
I'm going to make signs next week, and so next time we'll just all have signs say, I agree with Sue, or I agree with Stacy. We'll streamline comments. No, there are very few developers that I think bring as much attention to detail and community input and the ways in which you look at how these buildings take shape within the neighborhoods there. And I think this applicant has done an exceptional job of doing that. I think the building is very well designed. I think it does, to piggyback on what Stacy said, I think it does take an existing space and really bring something very new and nice to the neighborhood, and a very well addition to the city, right? It adds housing. Commissioner Levin back there talked about being in a housing crisis. He's not wrong. We are in a housing crisis. It brings 8 homes, permanent homes, because a lot of people talk about apartments being non-permanent residents versus these are actually residents, permanent residents living here. And so for all those reasons and more, and pending 2.6 gate or whatever we want to call it tonight, we can have I feel like we will get there, and I'm inclined to get there, and it feels good. So I am also inclined to support the project.
Thank you. Commissioner Hoopengarner?
I agree with Stacy. We'll get buttons. Yes, this is better, not bigger. And this developer, this architect, takes our green building code in its spirit, not just the letter of the law. And that's huge in this town. I just watched 20 trees get shredded last week. So a building can be built lot line to lot line, and we lost a 40-foot cedar and a 100-year-old Canary Island palm. And I had to leave the neighborhood because I couldn't watch the shredders. So here's an opportunity for us to put in so many more canopy trees than are even required, and across the board, shorter, more livability, much more open space, sustainability. Would tour that all of our projects were like this. I have every faith in our staff and my fellow commissioners in our ability to solve 2.6 gate. And with that, Commissioner Buckner.
Thank you.
Thank you. And I agree with Stacy as well, and also with Lynn. First of all, I think the variance is appropriate for this particular parcel, or a couple of parcels. I think that the modification is appropriate, considering what you get by giving. I was a little bit concerned about the no guest parking, and then when I realized that they're actually getting 3 extra spaces on the street for parking, so the guests could park there. So really, we're getting a +1 because they would only be required to do 2 guest parking spaces. So we're actually getting more for that neighborhood for use for their friends and neighbors who come by. I think that, as usual, this architect has paid really good attention to detail, making a very beautiful design, choosing materials that I think are going to really age well and will be beautiful to look at. I like the idea of having so much individual open space, patios that everybody can use. I think the central driveway and the way that the units would be able to interact with each other, I think it's a good neighborhood kind of design. I think it's going to be good, and that street is sort of a cul-de-sac anyway. It's a dead-end kind of thing. I don't think people are going to be driving back and forth, but they could walk up and take a look at really a beautiful project, so I'm willing to support it. And again, 2.6 gate.
Thank you, Commissioner Buckner. Vice Chair Bass.
Yeah, I don't agree with Stacy. I just had to say it to keep the theme going here. I generally do. And I do. I was trying to be funny. It didn't come off that well. But so I had some concerns about the guest parking, but as we discussed this, when I discussed this with the applicant, there are numerous ways they could get even fewer parking spots designing a different project. And so I do believe it's amply parked. I will push back in that the guests will have parking spots on the street by what they're freeing up, except that our condition in here also means that they will have to get day permits in the evening. They will only be able to get 50 per year. So that's required in the CCNRs based on our condition as it's already written. So anyone looking to purchase one of these units will need to do that. Although I think our city's moving forward with license plate readers, which will make it a lot easier to do, and they won't need to go get the paper ones. But it'll be good for the street as a whole to have a couple of additional spots on the street. So it makes an improvement to the neighborhood. When Rick was talking, he mentioned some conditions in Section 6 that might need some modification, and this commission discussed that on this previous Hilldale project, and so I think that we should instruct staff to make those changes as well. I think that they would be minor because it just asks for additional staff review and work. I want to talk a little bit. I think Elmer left, the neighbor who addressed the construction. Oh, you're in the back of the room. I was watching for you in your seat. This is the issues you raised are some that are very important to me as somebody who has a lot of construction going on in my neighborhood. They're in the packet. You can pick up the draft resolution. There are a lot of conditions in here, and I would point you specifically to, I believe it's condition 10.10. You asked about vehicles for the workers. So construction workers, they'll be able to get an encroachment permit in front of the projects because they'll need to have equipment and deliveries and stuff like that to come in. But I believe you live on the opposite side of the street. Their workers can't park in front of your place. They'll need to secure parking elsewhere and bring their workers in. And I would encourage you to get a copy of the resolution if we pass one tonight, and as it sounds like we will, and follow those conditions. And if they're violating the conditions of construction mitigation, let code enforcement know. They'll have a sign on their property with that. So I always look for those conditions because it's important that our neighbors are protected. As far as this project specifically, my colleagues have said this, with the 3 additional units to the housing stock in our city, the green space that's incorporated here that goes above and beyond. I think this is an exceptional project. And I want to talk about the variance because prior to Commissioner Erickson joining us up here, we had a previous, Rick brought another project on Hilldale across the street. The vote was 6-1, and I am a stickler for the rules. And I voted against that project because it did not meet the variance requirements for exceptional, extraordinary circumstances. And part of my argument to you all that night, which I didn't win, was that that project didn't meet that because there were 3 or 4 properties on the other side of the street that had deep setbacks. You all disagreed with me, and the fact that they're incorporating 3 of these projects, and you already as a body, we made that decision that, that the other project across the street will be set forward. Now this is the only property on the street affected this way. So my very argument against that other project argues in favor of the variance on this. I'm pointing to my notes if anyone wants to, it makes sense to me. But it is, my argument against that meeting the variance is sufficiently met here tonight. I would be prepared to move staff's report as written with the changes to section 6 as suggested by the applicant, but I am amenable if we can work out the language on 2.6 to go along with the consensus of the applicant, the neighbor, and this commission.
Great, thank you. I don't have an issue with a variance modification or parking reduction request. And I agree with the staff report that states the project maintains an urban form and land use pattern that enhances the quality of life and meets the community's vision for the future. I think this is a great project. It's appropriately named Facet, and like any faceted stone, this project has many faces, but it reads as a whole. And I think that is something very difficult to achieve with a project of this scale. And then it also provides 9 units that have unique courtyard experience and multi-height experience within each unit. I think this is an expertly designed project. And while I've been on the Planning Commission, I've had the opportunity to review 2 or 3 of Rick Abramson's projects, and have said this before, and I'll say it again, that I think the design standard here is one that all housing projects should try to achieve in the city of West Hollywood. So I agree with all the other comments made by my commissioners, and based on what the new language for item 2.6, then we can do a vote. Mr. Hu, do you want to?
Sure, I'll read it into the record. So, condition of approval 2.6 will be amended to read, if the applicant and property owner at 931 Hilldale agree on the terms of relocation and or augmentation of the solar panel system located at 931 Hilldale, prior to commencement of framing, the applicant shall pay 100% of the primary costs and any reasonable ancillary building permit costs associated with the relocation and or augmentation of the solar panel system, such that the energy generation is commensurate with the existing function at the time of installation.
So the problem I see with this, and I see where you're going, and it's close, is that you have an if clause without a clause, but more importantly, it kind of gives either party the ability to shut this down completely. And I don't think that's what our goal was. So how best to address that?
How about saying when instead of if?
So I'm confident that both parties are acting in good faith when they tell us that they wish to reach an agreement. We need to be careful with the language to make sure that if another owner comes in, or if there's a situation where somebody isn't acting in good faith on the neighbor's side, that we haven't now tied the project completely to someone else deciding yay or nay on any given day, right?
Absolutely agreed.
So, so working through that, we don't want to necessarily make this project moving forward conditional on reaching an agreement.
Excuse me. It is conditional if you say if.
If the applicant and property owners agree, then prior to the commencement of framing, I'm sorry, there is a then missing, you're right, Commissioner Hippengarner. Then prior to commencement of framing, the applicant shall do the following. That was the intent. It was, they need to agree, and then once they agree, this needs to happen prior to framing.
The only, like I said, the problem I have with this is either party, and importantly for the neighbor's perspective, the developer could just say, "No, I don't agree," and then this is gone. So, how to solve it?
We could start with a clause that says the applicant has agreed to pay for relocation.
There you go.
Period.
A statement of fact.
Yeah, we can do that.
Can we just get, I'm looking for a nod from the folks in the audience. I think that,
We can't hear you from there, please.
Yeah, it's not on the record.
We have the same concern. We're sure that this particular developer is very willing to come to an agreement with us, but you never know what can happen. The market's changed. Next week, they could sell the entitlements to a different developer who's just going to say, we're not agreeing with you at all, and now we have an out. And I understand why the developer would feel that we also have that ability here.
Can I suggest that, Jennifer, the applicant has committed to pay the relocation and augmentation costs of the property, and such payment and commencement of installation will begin not prior to commencement of, well, what did you say about framing? It's about
At completion of the frame.
at completion of
Yeah,
Framing.
Okay, so it's not prior to commencement of framing, shall be installed by completion of framing.
yeah.
Because it's about when that framing is going to start blocking the panels. So it's not about commencement of framing, that could be a couple months between commencement and actual completion of framing.
The idea is that the neighbor doesn't lose any solar power by that contributes to the construction.
So Jennifer and Lauren, you've heard all our comments, you've heard all our concerns. We could be here all night trying to fine-tune this text. Can we not move forward with faith that this has all been recorded?
I have a motion.
And I second it.
Okay, go
I
ahead.
don't know what it is.
what is the,
Well,
can you read the motion so that we know what the motion is?
Let's just remove it then.
So I just wanted to speak a little bit. We can add the language to conditions 6.3, 6.8, and 6.14 to add unless determined infeasible or undesirable by the Director of Public Works. That being said, we had extensive conversations today with Public Works Director and the City Engineer, and they don't feel that it's appropriate to waive or modify the standard in this case. We can always give them, reiterate, because the code gives the Director of Public Works already that flexibility if she finds that it is infeasible or undesirable. However, one point that was made is that it is not necessarily the purview of Planning and Development Services or the Planning Commission to weigh in on the public right-of-way, and that they did not feel that in this case it was appropriate. So I just wanted to
Who
carry
did
that
not?
message forward. The
Public-
Director of Public Works.
Can you speak to what those modifications were?
I don't know exactly what the applicant is asking to modify about the parkway and sidewalk. I don't know if it's a full waiver or shortening it. However, we feel pretty strongly that this is a standard that's in the code. It's applied to every project that comes in. Yes, we have inconsistency, but that's what happens when we have to do project by project to acquire these parkways and sidewalks. And if we don't do it on each project that comes forward, we will never have a sidewalk and parkway and street tree situation on these streets that don't already have them. So that's the Public Works feedback on that request. So again, I don't see that there's immediate harm in adding that flexibility to the condition. It already exists in the code, but just so that you are aware of the full information, that was the response from the city.
I brought that up, and I would like to include it because that would make it consistent with the other project this commission approved across the street. And if it doesn't really make an impact, That person at City Hall will make that decision ultimately. Let's weigh in and say, that we think this one street on Hilldale warrants a second look.
Fair enough.
To be clear, which paragraphs were those again? 6.3?
6.8 and 6.14.
6.8 that I was missing. And so you're just adding that final sentence to each one of them?
Yes, on 6.3, it would go after the first sentence, after the word Hilldale Avenue. So provide sufficient public right-of-way dedication as necessary to provide 10 feet wide combined public sidewalk and parkway measured from the public curb face along the entire property frontage on Hilldale Avenue unless determined infeasible or undesirable by the Director of Public Works. On 6.8, it would go after Hilldale Avenue in the second sentence. So the second sentence would read, sidewalks shall be 5 feet wide and adjacent to the right-of-way line. That was the third sentence. Install public right-of-way landscape parkways along the public property frontage on Hilldale Avenue unless determined infeasible or undesirable by the Director of Public Works. And on 6.14, it would go after, well, this is already to the satisfaction of the city engineer, so I'm not sure that this needs to be modified, but if you want to modify it, it would go after the words city engineer in the first sentence. Unless, again, it would read, install public street trees along the property frontage on Hilldale Avenue to the satisfaction of the city engineer unless determined infeasible or undesirable by the Director of Public Works.
Do we need additional time to come back with this cleaned up resolution?
We have the language on the screen. I think we can probably make it smaller so it all fits on the screen. So it's up to the commission, but I think we feel comfortable that it's been well vetted.
And because this flexibility language has been in another resolution before, we've seen what it says in those 3 conditions. So we're comfortable reading it into the record if you are.
So you don't need to bring back a resolution. We take this as it's cut and pasted.
Yeah, I think we can
Okay.
we can read it into the record.
Great.
Mr. Chairman, if I could,
Please.
we are agreeing with our neighbor. The statement or the phrase in there in regard to mutual agreement is basically everything would be in good faith. We would hope that we would be able to come to an agreement, but if one of us doesn't, we vetoed the project. And that, to us, I think, to both of us, I'm getting nods from the neighbor, is a problem. So, I mean, one option, I'm agreeing with you, Commissioner. I mean, one of the options might be to allow the director to review and make a determination, but look, we are working as diligently as we can in regard to coming to an agreement, but maybe that doesn't happen.
Who insisted on this
I'm sorry, I couldn't hear you.
Who insisted on this condition of non-disclosure?
I'm sorry.
The non-disclosure agreement is something that I'm assuming was drafted up between the applicant's legal team and the neighbor's legal team?
When we had received the agreement from their counsel, there's a confidentiality clause.
Settlement negotiation, it's part of
I can't. I'm not going to break that. I can't.
That came with the agreement that was submitted to you?
I'm sorry, say again, sir?
The confidentiality came with the agreement that was
Correct,
submitted
yes.
to you?
Yes.
So here's a suggestion. Instead of if they come to an agreement, this statement is that the applicant has agreed to pay, okay? If we leave it to the discretion of the neighbor to determine the installation, then it's in writing that the applicant has agreed to pay.
But what if the neighbor doesn't agree, doesn't confirm the installation, or doesn't?
Then that's the neighbor's choice not to do the installation.
But that goes back to my point of saying, approve with direction to resolve within 60 days, or the neighbor gets nothing. Because that basically you're saying then she doesn't get installation, so then she won't get solar panels.
I want to go back to the code, and it says that the review body may modify this requirement if strict compliance would unduly limit property development or unduly interfere with the development potential as envisioned for the area. I believe that condition 2.6 as written would do that. And so I know we have a motion and a second on the floor, and I believe Commissioner Hoopengartner and I are disagreeing on that. So I'm going to offer a substitute resolution.
I'm going to remove my second.
I'm going to offer well, if the second's been recalled.
I can't do that, David, but I'm removing my second.
My motion, if there's no second for the one that's on the floor.
Well, nobody knows what my motion is, but.
I thought we were getting there, but
I thought we got there. So
sounds like.
Commissioner Hoopengartner, will you let us know what your motion is?
I would like to move that this paragraph be rewritten and address, as we've discussed, to the agreement of the two parties, and that this be brought back to us on consent next meeting, although I don't know when our next
November
meeting is.
21st.
That would then these modifications be addressed on consent, and the parties would then have time with council to draft language that would meet both parties' goals, and we would be able to review it on consent. And I think we've had enough conversation at this point. We know exactly what the intent is. Now it's a matter of crafting the language in a way that meets both parties' needs.
I think that's reasonable.
I agree. And we will include a time frame.
I think it should have a time frame.
Commissioner Erickson's request. I agree.
I don't have a problem with that, and that would be my motion.
But the time frame being what? When it comes back to us on consent?
No.
In the language of 2.6, a time frame for the installation.
But I guess I'm confused. Are you saying that you wanted to come back on consent to us at our next meeting because that gives them time to agree?
Language.
And the language.
But what if they don't approve it by then? That's what I'm saying.
Then we decide.
Then we decide, and obviously, according to what Adam read, and it says so here in our staff report, that we can simply take out that 2.6 language and approve the project without the applicant paying for the solar panels. That's where I was from the beginning.
I believe that the original 2.6 says that they need to provide evidence that they've attempted to do this to the satisfaction of the director. And I believe if the conversation we're having here is that staff's heard us, staff's heard us, staff's heard us, well, staff's heard us, and this director's not going to determine that that has been met unless there is a good faith effort to meet those, so the alternative motion I was going to suggest is we approve as written with the changes on section 6 as read into the record. I know we have a motion on the floor. I don't know if it's been...
Well, I removed my second, but it sounded like Commissioner Alschel did agree with what Commissioner Hoopengartner said. So if there's a motion and a second, we should vote on that motion. And if it's up or down, and it can go on to what Commissioner Hoopengartner's motion is. If not, it can come back, and it sounds like Adam has a motion that I would be more inclined to support, because I do agree through our conversations that we've been having here that, and it doesn't sound like the applicant or the other person is too happy with this one right now, and so I
think that this is a complicated set of, the framing this language is doable, but it's not something you do by committee at this hour. And that's why my motion is simply that we lock the applicant and the neighbor and legal counsel in a conference room, let them craft the language and bring it back to us at the next meeting, next hearing.
On consent.
On consent.
And we have faith that they would do that even though it's taken months to get to this point.
Well, they didn't discuss this language.
Well,
No, but they've been discussing the
fighting over
panels.
this
they've
for
been
months.
fighting over this language and this issue.
So we've given
And-
them an opportunity, via my motion, we've given them an opportunity to come to an agreement. Failing that,
We can take it off consent.
we can
and-
take it off consent, we can remove the item altogether, we can make that decision at that time. But I don't think we're going to come to an agreement on 2.6 in the exact terms. We bring things back on consent all the time when we do heavy-duty lifting on a language, and this is heavy-duty lifting on some language.
So on
Mike-
November
Mike-
21, it comes back on consent, and at that point, we can decide whether the language reflects our conversation and all the comments made here. If it doesn't, we pull it,
Exactly.
and the option goes away.
What happens though if they haven't reached an agreement?
It couldn't be on consent.
Then we can.
Then we'll
vote.
I'm
pull
just
it
saying
out.
that it sounds like we have consensus here to we can make a decision here. And I'm literally looking at two lawyers sitting there shaking their heads saying they don't like this. So, I mean,
Hey,
you
this
didn't seem like
happens
you
all
were
the
happy about
time,
it. I'm not
guys.
saying, if you are not happy with this, speak now or forever hold your peace. Because this project has, from what we're seeing on the merits, 7 votes.
John, I am not happy with this language either. I think that's what we're all saying, that this language is, we know where we want to head. This language isn't there yet, but I think it's achievable with both parties and legal involved, and that they can bring us back on consent. At that point, hopefully agreed upon terms that everybody's agreed to.
I think Lynn is correct. However, if they can't, we can revert back to 2.6 as the staff originally wrote it.
And
And
I would-
whoever's unhappy can appeal it to the council.
And I would
Exactly.
make that part of my motion, that if they are unable to come to an agreement, that we would revert to the existing language.
It doesn't sound to me, to clarify, like either party has an issue with 2.6. It's the fact that they haven't actually, I don't recall either of you having called out that the language in 2.6 was particularly troubling. It's the fact that you haven't, it's the fact that you haven't actually come to an agreement yet.
Well, the neighbor expressed the concern that, in fact, 2.6 excludes the neighbor from the conversation. And then this is where my original attempt was to include the neighbor in the language, include it as a conversation, and make sure that all parties were involved. The current language under 2.6 completely disempowers the neighbor.
It doesn't. That's not true. The intent
doesn't.
of the planning department, or whatever you're called now, John, division, he would intend to, and he is shaking his head, to do exactly what Adam is saying. You disagree. I understand that.
But it's not in writing.
But he will get it right.
So,
I'm aligned with Adams.
And I am
Commissioner
too.
Hoopengarter, does your motion have a second?
Yes.
Who was the second?
No,
I removed my
John
second.
revoked his
For
second.
Elchel.
I'll second.
Can I, I'm sorry, Chair, may I, please? I'm so sorry. There's a couple of points I just wanted to clarify here. If you adopt a resolution tonight, or you don't adopt a resolution, but you approve the project and then direct the resolution to come back on consent,
And then you pull it.
recall that you would have to renotice the item if you wanted to change any of the conditions from what was spoken into the record tonight. There's a suggestion of putting it on unfinished business so that it can more easily be redone. That is continuing the item. The other, I don't know if you want any more. I just wanted to also clarify the motion in terms of the condition. You wanted to have a time frame. You wanted to have some oversight over the process of the agreement, correct? I just want to make sure that we get everything so that we don't have to argue it back and forth when we come back.
I think point one is the commitment that the applicant has made multiple times that they agree to pay 100% of the costs.
Okay.
And the commitment that the neighbor will actually cooperate.
And to facilitate the actual installation.
Yep.
So,
Okay?
But it's not
And-
about solar panels. Like, this is, like, he can't
Don?
literally talk about certain things. So that's why this motion is moot. Like, he literally cannot talk about things because of a non-disclosure and confidentiality agreement. Like, there are an agreement on solar panels.
Go to mediation.
John,
Well, that's too, but, you know.
I don't believe we can attribute beliefs and actions to other people in the absence of their stating those things, so I would be very leery of asserting what's
I'm not
really going
asserting
on.
it, Lynn. I'm trying to sit there and say we have an applicant that has said he cannot talk about certain items, and we have literally for 3 hours hashed out the sheer fact, 2 hours, thank you, the sheer fact that they are getting new solar panels that are better than the other ones, and that's not even the issue. So I'm just saying, like, I hear what you're saying, and
How do you know it's not the issue?
Can we just have a
because they
vote?
love
Alright.
the solar panels, so here we go.
As a matter of process.
Can we have a vote on your motion?
I believe, one other thing, I'm sorry, is
let's
that
have a
I
vote
believe
on
a
this
substitute motion is in order, and I would like to make a substitute motion that we approve staff report as written with the changes to section 6 as read into the record. That's my substitute motion.
I'll second that.
What are the changes?
Okay,
It was
but
this
we
is
have
the
a
change.
motion
We
on
have
the
a motion on the
table.
floor.
So we need to vote on Commissioner Hoopengartner's
You
motion.
vote on the
which is-
substitute motion first.
You vote on the proposed substitute first.
Okay.
So let's just
I'm
clarify.
not sure I understand what we're
Okay.
voting on because,
The- Commissioner Bass made a substitute motion
yeah.
to approve staff's recommendation only with the changes to section 6 that have been read into record about flexibility with the Public Works Director determining the size of the right-of-way dedication.
that's-
To the 3 conditions. Those are the only changes.
So to approve staff report as it exists, that's the substitute
Yes, with-
motion with the changes, with those items that require the,
But no changes to 2.6.
No,
okay.
no.
So wait. This is not, we need to, what I'm saying here, that the mover was Hoopengartner and that was seconded by,
We need to clear
We need to
Commissioner
clear this.
Hoopengartner's motion.
yeah, this is the original. It was Hoopengartner and Erickson. We need to sue Bass and
We
Jones.
can't vote on this.
I'll second. There we go. Okay.
Okay, that motion passes, noting Commissioner Hoopengartner voting no.
It's done.
Okay. Next, we have new business, and there is none.
Does
Yeah, David, do you need to read the appeal?
Thank you, yes.
Yeah.
The resolution the Planning Commission just approved memorializes the Commission's final action on this matter. This action is subject to appeal to the City Council. Appeals must be submitted within 10 calendar days from this date to the City Clerk's office. Appeals must be in writing and accompanied by the required fees. The City Clerk's office can provide appeal forms and information about a waiver of fees.
Thank you, David. So we have no new business. Do we have any unfinished business? None. We have no excluded consent items. Do we have items from staff? Yes?
Yes, in case you haven't heard me enough. All right, so we have no items scheduled for November 7th, which is our next meeting, so that meeting would be canceled. November 21st looks like it's going to have an earthquake fault zone map update and the general plan consistency finding, and we're going to bring a commissioner training to talk about, I'm sorry, yeah, on the 21st, to talk about purview and exhibits and CEQA and what, a number of different topics, building permits and things like that.
What about items C and D on the agenda? Oh, those are consent, okay.
And then, let's see, and that's all I think I have for this evening.
Thank you. David, do we have any public comments at this
We do.
time?
We have one. Edward Levin, please.
Mr. Levin, thank you.
Thank you, Chair. Thank you, Chair. Edward Levin, resident of West Hollywood. I'll try to be brief. I submit the last 2 hours of discussion as Exhibit A in the need to clarify the solar ordinance. And you also need to have dispute resolution in there. It is quite correct to leave the Director of Planning in the middle of this. A number of years ago, better part of a quarter century, we did a project on 3rd Street Promenade that involved a building with a party wall. The city building official said, because the building next door is going to be demolished, that our client needed to sign a covenant. She balked. We kept telling her, you have to sign this. And the city building official said, if she does not, I will execute the covenant on her behalf, on the city's behalf for her, because the city building official has power to be able to do that on adjoining properties. And so what I would suggest that you do is any 4 of you can decide to agendize a discussion of this item to recommend to City Council that they have staff study this, changes to the solar item, including dispute resolution, and bring it back to you for your consideration to recommend changes in the ordinance to council. So any 4 of you can decide to do this. I seriously suggest that you do so. The other thing I will say is 3D computer models. I go back to the dawn of 3D computer models, literally 1972, when we were trying to figure out how to paint the planes in order so that we could make a wireframe look like an actual cube. It was simple then. These days, our 3D computer models have embedded in them details of windows that we've drawn, all sorts of other proprietary information that we've created. We do not give our 3D computer models to outside parties. Under some circumstances, an environmental consultant, we might, in the context where there is a dispute and where there's an adverse party, under no circumstances would we give them our computer model. So, because nowadays they have substantial amounts of proprietary information in them. So there should be no expectation of sharing at this point. So just for your information, your sort of general information about how that proceeds in this day and age. Thank you.
Thank you, Mr. Levin. Do we have items from the commissioners at this time?
I just want to thank you, Chair. That was a fun meeting, and you did a spectacular job. It's always fun. I actually don't know what was going on, like with the public hearing. I was like, because we did, it was a good time. So thank you very much, Chair. It was very well done.
I'm glad everybody had a nice night. So do we have any subcommittee management announcements? Is everybody going to be present for the next several meetings? Yes? Commissioner Buckner?
Yeah, the only one that I would miss has been canceled, so.
Great, so then we're all on board with the current schedule. So this adjourns our meeting to our next regular scheduled meeting, which will be Thursday, November 21 at 6:30 here in Council Chambers. Thank you.
Thank you.
Wait a minute, November